I'm just gonna wait for people to tune in before I get started. And as always, as you're tuning in, let me know where you're tuning in from, what city and state, or what country are you tuning in from. I am in sunny Florida, in Orlando area. So tune in. I'm gonna wait like about 30 seconds before I begin. And as always, I always have a good topic for you guys today. If you're on Facebook or YouTube, say hi in the comment. Let me know you're in here. Instagrammers, don't be so shy and quiet. Comment in the box. Say hi. Let me know where you're tuning in from. I'm just gonna wait a couple for you guys to all come in. Welcome. Hi, Kim. How's it going? Longest time. Thanks for tuning in. Good morning, Macedonia from Washington State. It's super early in Washington right now. And good morning, Nazon from Orlando. For those of you on Instagram, I'm talking to people on Facebook, in case you're wondering. Wow. On Instagram, hi, Epolato from Abuja, Nigeria. Thank you so much for tuning in all the way. I'm from there. And Esther from Ghana. Oh my goodness. You guys are like, global. Thank you guys so much for tuning in. And by the way, I am loving this filter on Instagram. It makes me look totally fabulous. For those of you on Facebook, I'm just talking about my Instagram filter. Okay, so let me introduce myself. My name is Ayesha Chidolue. I'm an immigration attorney here in Orlando, Florida, but I represent clients in all 50 states and internationally. As long as you want to immigrate to the United States, I would be happy to assist you with your family immigration matter. Alex on Facebook says you're global. Thank you so much, apparently. But I guess that's the wonderful thing about social media. Everybody can share it regardless of where you live. So for those of you tuning in, let me just give you my number just in case you want to call us. It's 407-995-6567. It's also on the caption on Facebook and YouTube. And if you're on Instagram and you didn't catch my phone number, it's also in my profile, so you can see there to call the office. So today I want to just talk about parents and children that might qualify for a green card in a non-traditional way. So, I know for some of you that follow me for a while now, you probably know a little bit about what Vawa is and how it helps immigrants get visas. So if you're new here, let me explain that to you guys. So Vawa is basically called Violence Against Women's Act. So, don't let the word women fool you in there, because people who qualify are both males, females, parents, children, and spouses. But today I just really want to focus on parents and children and the requirements for them to qualify. Liz Grin says, thank you for getting back to me. I'll be in touch with you as soon as I have my things sorted out. Awesome. Thank you. So typically, most of the time when, people hear VAWA, they usually think about, husband and wife filing for each other. I mean, a wife filing because her spouse is abusive or something like that. So again, today I want to focus on children and parents. So let's start with the parents. So in order for you as a parent to self-petition based on your child being extremely cruel to you or abusive to you, your child has to be a U.S. citizen. That's number one. And your child has to be 21 years or older. So you notice that this is a little different from spouses, because, with spouses, you can be a green card holder or you can be a U.S. citizen. The person, when I say you, I mean the abuser can be. But with parents, the abusive person, the abusive child must be a U.S. citizen. They must be 21 years old or older. So for a lot of parents, this is something that's definitely very challenging for them, being able to acknowledge that maybe their child is abusive or their child has been extremely cruel to them. So today, I just want to kind of give you some different types of examples of cruelty or parental cruelty. Obviously this is not an exclusive list. It just really depends on, your own situation, and I'm happy to evaluate you to know what's going on. Good morning, everybody. I'm not ignoring you guys. I will go back and address everybody in the comments, and definitely put your questions, because I will answer your questions once I finish. So when you're thinking about cruelty, you want to think about, if you had children or a child who, maybe you're a parent who crossed the border for a better life, and then when you came here, you had your child and your child became a US citizen. Or let's say you living with your child, was skipping school, doing drugs, stealing, doing, things like that, threatening you as a parent, to making you feel bad as a parent. Like sometimes some children blame their parents for their life, right? And for what they've not accomplished, and things that, or saying cruel things to you. Or sometimes you have a child threatening suicide, but not necessarily because they want to do it, but as a way to manipulate, the parent, into submission. And so every time, you want to discipline your child or talk to your child, there's always that PTSD or fear that, well, what if the child does something to themselves? Again, this is not an exhaustive list, because parents, it's really a very delicate issue. And so it's always really important to evaluate the parent and just get true knowledge and understanding of the dynamics of the parent-child relationship, to be able to say, what is this person experiencing? Because, for a lot of parents, this is your baby. So, there's that fear that, well, I don't want to say that my child is bad because it means that I'm a failure, right? Or something's going to happen to my child. So the first thing is that this doesn't have anything to do with your child, and it doesn't affect your child, because Vawa is an extremely confidential process with USCIS, and it protects you, the petitioner, of it. So nobody's coming to your child or saying anything about your child. And sometimes, and then for us as counselors, we're not judging you. We're not judging you. It's life, and sometimes it happens. Sometimes as a parent, you can do the best that you can, and your child might still turn out that way. So if you're in that situation, or anybody that's in that situation, definitely tell them to call me. I'm happy to evaluate them to see if they qualify. One of the good things about this, if you do qualify, or the bright light, I should say, is that even if you cross the border, came here without papers, or you came with a visa and your visa overstayed, you will still qualify to adjust your status and get your green card here, and you will get a 10-year green card, and be eligible for citizenship, after you've had your green card for some time. So that's it for the parent standpoint. And then I want to talk about the child standpoint. The child standpoint, in order for the child to be eligible for it, the child, so there are a few tricky things here, so you got to pay attention. It can be a US citizen parent or a green card holder parent. So you see, it's different with a parent. For the child, the person that's extremely cruel to you can be a green card holder parent, and it can be a US citizen parent. And you can qualify. Oh my goodness, my phone is off the chain, and so it's stopping my live. Sorry guys, live on Instagram, the phone keeps ringing. So it's stopping the live. Sorry guys. So like when you're a parent, when I say parent, I mean both biological parents or step parents. So let me talk about, because we see this more with step parents. So let me talk about the step parent dynamic. So if you are a if you're a parent, let's say your mom, let's say your mother got married to somebody else that's not your biological father, that marriage has to have taken place before you turned 18 for you to be eligible as a stepchild. That's number one. So if your mom got married when you were 19-year-old, you no longer qualify. That marriage has to have taken place before you turned 18. And then if while during that time you experience that, you can file to self-petition up until you're 21, okay? After 21, if you didn't file, they make certain exceptions to a maximum of 25 years old. Oh my goodness, my phone is going crazy today. So they make exceptions to your case if you didn't file before you turn 21. But the only way they will make an exception is if you can show that it's because of the abuse that you never submitted your petition on time. Like if your own mother is being abused, and your own mother is the one who supports you, and she couldn't even help you file the petition because she herself was in an abusive marriage. So a lot of times they're looking for you witnessing that abuse to your own parents, or you being the victim of the abuse as a child. So that's how it works for step parents. And in the same regard, once you file the process, you'll get your 10-year green card. One of the requirements for this two-parent and child is that you have to show you're a person of good moral character. So one of the things that's required is an FBI clearance report or a police report. If you're under 14, you are presumed to be of good character, so you're exempt from the police report or FBI report. But if you're over the age of 14, you need to show that you're a person of good moral character and that you don't have any crimes of moral turpitude. So that's how qualifying for VAWA as a parent and a child goes. If you have a particular situation, or your parents do or your sibling does, definitely have them give me a call, and then I can evaluate their own particular situation. Okay, guys? So let me go through and answer questions. So on Instagram, someone says, if you update your address on USCIS, how long do they take to make a redelivery of the mail to your new address? You're probably not going to get a new redelivery. You're going to have to contact them. So it just depends on, so did you update after they delivered? Because that's going to be a problem. So that's the first question, when did you update it? So you might want to try and see if you did, I don't know. So if in the future, I don't know if you did this already, if you updated your address and you did like a USPS, where they do a mail forwarding, hopefully they'll forward it to you. But the minute you move, you want to update your address. And this is for all of you that are thinking of moving and have something going on with immigration. It is truly a nightmare to wait until they've mailed you something to say, oh my goodness, I've updated my address. The minute your address changes, you want to send an update. It is very easy to do that online, or have your attorney team help you do that. So don't wait till you've moved and you've missed the mail, especially if the mail is your green card, or if the mail is your green card or like your work permit, because what's going to happen is they're first going to have to wait till USCIS gets it back as a returned mail, however long that takes. And you're going to have to fill out another I-90, basically saying that you never got that mail. And it could take like a year, like literally, I'm not joking, for you to get that back. So I really hope that's not what the mail you got is, because I'm sure that really sucked. Okay, so let's see what questions here. Julia says, hi, lawyer. I want to talk with you. Happy to talk with you. Call me, 407-995-6567. All right, so let's see what other questions we have here. What if the petitioner passes away before filing the I-130? Is there a way you can still file? Absolutely. So if the petitioner passed away, and I'm assuming the petitioner is your spouse, you can do a petition based on you being a widow or a widower. The only thing is that you want to make sure that you do that within 2 years of them passing away. So I don't know when the petitioner passed away, but you want to try and do that. Obviously you're still going to have to show proof of a bona fide marriage, proof that you were the spouse, death decree and all of that stuff, and is within the timeline, and then you can certainly do that. Okay. And then for those of you who already have pending I-130s and your spouse passes away, you can notify USCIS, and then they'll convert your I-130 to a petition based on you being a widow, as long as you provide the documentation. If you don't provide the documentation and they deny, then you're going to have to file and pay again. Okay. Somebody asked on Facebook, how long will it take to get my green card if my wife, who's a green card holder, files for me through marriage? Well, honestly, the answer really depends, Nazon. Where are you? What part of the world are you in? So let me see if you wrote that. Okay, well, so you're in Orlando, right? So using Orlando, for example, if your spouse files for you, the only way for you to adjust your status in the United States is that you have to be currently in status. Meaning if you're not in status right now, when I say in status, I mean that you have a current visa and your I-94 has not expired. then you're not, if your I-94 has not expired, then she can file for you simultaneously right now. If your I-94 has expired and it's been more than 6 months since it's expired, you are going to need a hardship waiver. She's not going to be able to adjust for you as your spouse while you're within the United States. I think I froze on Facebook. Can you guys hear me on Facebook? Okay, it looks like it picked back up. You're going to, what's going to happen is she's going to have to file the I-130. Once you get the I-130 approved, you're going to have to do what we call a hardship waiver. And you're going to need qualifying relatives to prove hardship. Qualifying relative in this case would be a spouse that's a U.S. citizen or a green card holder, or a parent of yours that's a U.S. citizen or a green card holder. So they're going to have to show hardship that if they don't let you come back in, it's going to be hard for them. And then once they approve your waiver, then you have to go back to your home country to do your interview and finish the process. So if you do it that way, it's going to take you a long time. It's going to take at least, it could take at least like probably more than 24 months, because you're going to have to first do the I-130, 6 to 12 months if they approve that. And again, this is not legal advice I'm giving you. I'm just giving you normal estimated times, which of course it can be give or take any of the two. And then you then do the waiver, which could take another 8 months. And then you then do the interview, and then that takes time of its own. So that's kind of how it works, unfortunately. So if your wife has the ability to become a citizen, then let her become a citizen, because if she becomes a citizen, then she can still continue to file the I-130 for you while pursuing the citizenship route. And then when she becomes a citizen, then you can just convert and do an adjustment of status. That way you won't have to leave the country. Hi, Hannah Kella. Good morning. How are you? So somebody asked, how long does a parent with a green card file for an adult children? So the answer to that question depends on what month you file. So the way it works, for those of you who don't know, when you're a green card holder filing for a child, your child is not considered an immediate relative. You're not child. For a son or daughter, I've explained this before, but let me explain this for you guys that are new here. USCIS considers children as children that are under 21. If you are over 21, you're considered a son or a daughter. That's what they refer to you as. And when you're a son or a daughter, right now the wait time for green card holders filing for an adult son or daughter who's unmarried is about 5 years. So that is as of the month of May. When they release the June bulletin, that might change. So it changes every month. So the only way to get a true and accurate picture of how long it's going to take is after you file and they've captured your priority date. But just know that it's around, 5 to 6 years, basically, to do that. Let's see. Somebody asked, how long does it take to get U.S. citizenship if you've been married to a U.S. citizen for more than 4 years? So Candy, the answer really depends on when you have become a green card holder. It's not how long you've been married, but are you a green card holder? If you're a green card holder and you got your green card due to you being married, oh my goodness, these phones are crazy today. Usually before I go on those lives, I mute my phone so that it doesn't ring, but I just don't know how to do it, and I didn't do it before. So sorry, guys. I know it keeps cutting you guys off on Instagram, and I apologize in advance. But as I was saying, so if you get your green card through your U.S. citizen spouse, then you can petition for naturalization to become a U.S. citizen after 3 years of having your green card, right? If you got your green card not with your spouse, then you become eligible after 5 years. So it's not a question of how long you've been married to the citizen. It's a question of how long you've had your green card and what how long you've had your green card and how did you get your green card? Was it through the diversity visa lottery? Was it through work? Was it through your spouse? Was it through your parent or your child? All those things make a difference. So I hope that answered your question. Somebody on Instagram said, what does it mean when your passport is stamped no AOS permitted? What it basically means is that they're saying that you shouldn't come here to immigrate. It means do not come here and try to do an adjustment of status. So that's essentially what it means. So somebody on Facebook says, how long does it take to have an I-765 approved on a C9 category? So the answer really depends. Right now, the timeline is about 5 to 8 months, give or take. Again, when we give this timelines, there's never really a method to the madness, meaning, I could say 5 to 8 months and you can be lucky and you can get in like 4 months or 3 months, or you could be one of the unlucky ones and you get it in 9 months. But I will say that on average, most people get it within the 5 to 8 months, with 6 to 6.5 months being the normal time. So that should sort of where your headspace should be. Okay. So Favorite Carrie says, how long does it take for a U.S. citizen in the Navy to file for a parent? So the timeline is the same. There's no acceleration. The only thing is that, when you have a child that's in the military, in the U.S. military, that's a U.S. citizen filing for a parent, you can get what we call PIP. So that's like parole in place, which basically means that they will forgive you if, let's say, you cross the border, as opposed to the normal route. If your child is just a U.S. citizen and not in the military, you can't cross the border. You're going to need to do a waiver, or you can qualify based on VAWA. Okay, so let's see what other questions. Hannah says, you're an amazing person. Thank you so much. So are you. Let's see what else. Can you guys see how crazy the calls are today? So you guys, when I'm not available to answer your questions, this is why, because it's super busy. Someone says, can having an STD, STI prevent you from getting an immigration benefit? So that's very specific and it depends on what it is. I'm happy to discuss with you. If you have a particular scenario, call me 47995-6567. Okay, and then somebody on Facebook says, how long will it take for a U.S. citizen parent to apply for a son or a daughter? So when you say son or daughter, you're talking about 21 or over, right? So believe it or not, as of right now, it actually is taking longer for you as a U.S. citizen parent to apply for a son or a daughter that's over 21. It's taken about 6 years compared to green card holders where it's taken about 5 years. Again, that is just for the month of May, because, like I mentioned before, when you are in what we call an immigrant preference category, every month they change the dates. Every month they change the dates. I mean, we can give you like averages based on, what the year projection is or what each calendar has been. But right now the calendar is basically like, 6 months. So Dimitri asked, what is the prima facie determination letter given applicants? So depending on what state you're in, it will allow you to get your driver's license. So if you're in the state of Florida, it will allow you to get your driver's license. It will also allow you to get financial aid, like to go to school, right? So your prima facie is renewed every year. So as long as you're in school and your case is pending, you have to continue to make sure that your prima facie is renewed. Most of the time, they will do an automatic renewal right before your expiration. So if you're a student or you want to go to school, you want to go to college, you should be able to get some public assistance to go to college and get your driver's license with that. Somebody asks, how long does it take for USCIS to respond to you after receiving your application? So that question is super vague. It's just so super vague because of what application, the first thing that you get when you submit any kind of petition to USCIS is your a filing receipt. And a filing receipt is really based on how what case you file, because the processing time is different for all cases. Let me use an example. For conditional green cards right now, it's just taken a really long time to get filing receipts, right? Whereas if I send a petition, it might be coming quicker, but give or take, it could take anywhere from 3 to 8 weeks, just depending on what your petition is. So that is the first thing that you get from them. And your filing receipt is an important document because, it gives you, if you've never been in the immigration system before, it gives you your alien number. And it gives you your receipt number where you can be able to track your cases. Somebody says, can you travel out of state with a pending I-485? Well, do you have you gotten your work permits? Have you gotten your travel authorization? I always say, if you want to travel out of state, wait till you get your state identification. And the way you get your state identification is when you get your work permit, just, for just in the abundance of caution, like I'm one that believes in just being cautious and just not putting yourself at risk. If you want to travel, drive and just wait until you get your work permit. And then if you want to travel out of the country, wait till you get your travel permit. If you travel out of country without getting your travel permit, basically you've abandoned your application and you're not going to be able to come back. Okay. So Fitzroy Blake says, I'd love to talk to you, and I'd love to talk to you as well. Definitely give me a call, 407-995-6567. Okay, so let's see. How soon after a U.S. citizen child files for a parent after finishing basic training? I'm not sure I understand the question you're asking. Are you in the military? Is that what you're asking? So Gerdine says, after receiving your receipt from USCIS, what will be the next step? Again, this is another very, very vague question because it depends on what petition you filed. So the steps are all different depending on what you filed with USCIS. So it's hard to answer your question. If you have a particular situation where you filed and you just kind of want to know what's the life cycle of your case, you can call me and then we can go over that. Says, can you file for adjustment of status for a child out of the country under VAWA? So no, you cannot file for adjustment of status for a child out of the country. So let me explain that, just because it's very particular. So if you file for a VAWA application as a parent, because you're not as a parent, as a spouse, right? All your children under 21 years are eligible. But eligibility changes depending on how it works, changes depending on where your children live. So if your children live here in the United States with you and you're submitting an adjustment of status application, you can also submit an adjustment of status application for your children that are here within the United States. What are the benefits of that is that at least it will allow them to get their work permit. Even though your children may not be planning to work, but it allows them to at least have an identification, and it also allows them to have their Social Security number. For your children outside of the United States, they are going to be automatically included in your I-360 petition only. Your I-360 petition is not your adjustment of status petition. Your I-360 approved you for VAWA. Your adjustment of status petition approved you for the green card. When everybody's in America, we try to file, and there's nothing stopping us from filing it all together. We file it all together just to make the process easier and to get your stuff quicker. When the child is outside, what will happen is you will file and your child will be included as a prima facie determination recipient along with you. And then when you are approved for the I-360, then you can convert the child's petition to consular process. So you will then go with that approval to submit for approval for your child outside the country. Now, if your child so happens to come to the United States after you've petitioned and ends up staying here for a little while, you can update your application or your child's application and add those together. So I hope that's clear. It's a little bit iffy, but if you have a particular situation, you can definitely ask me. Call me actually, and we can discuss. Someone said, I sent my I-131 since October last year, but it had a mistake on the category. Now I tried to correct it and send it back. Are they going to consider the initial date or the correction date? I-131s, what do you mean category? What do you mean category? It just really depends, but again, because your stuff is specific, don't give me your business on here. You can call me to talk about it. So Ifam Azar says, I filed for adjustment of status, but I've not received my filing receipt. When did you file? The timeline, it really varies. It really just depends on when you submitted it. Honestly, adjustment of status sometimes can take like 8 to 12 weeks. It's super annoying, but that's what it is. But hopefully you get it sooner rather than later, and make sure. And then if it's taken too long, usually when I submit a petition, if a petition is taken too long, then it leads me to believe that there's something wrong with the petition, and that they're probably going to send it back. So like when there's something wrong with your petition and they're going to send it back to you, you're not going to get a filing receipt. You're just going to be like, okay, it's been like 8 weeks, 9 weeks, 10 weeks. I haven't gotten it back. And then, the next thing you get the entire packet back with what the issue is. Okay, so Ifema says, I filed it 3 weeks ago. Girl, you're fine. You just filed it 3 weeks ago. You just got to be patient. Like, you're still within, the time. Like, it's only 3 weeks. Calm down. It's coming. So somebody on Instagram says, what is the minimum income requirement? My phone is literally going to die on Instagram. And if it dies, you can hop onto Facebook. Otherwise, sorry about that. She says, what is the minimum income for a single USA citizen filing for her spouse? She also files taxes as single. So the minimum income is $21,775. So your spouse has to show that, her adjusted gross income is at least $21,775 to be able to sponsor you if she claims single and nobody else. Okay. Hi, Nahimia. Hi, Nahimi, how's it going? All right. So I know I saw some YouTube questions. Let me try and get to those questions. So Ray on YouTube says, what if you already have the marriage-based work permit? Can you still apply for VAWA? Yeah, if you're having marital problems where your spouse is extremely cruel and abusive, absolutely. You can actually do a combination and, withdraw from the marriage base and then do the VAWA. So, I hope you're not obviously in an unfortunate situation like that, but if you are, you definitely have options and you don't have to suffer. Call me and we can see how to help you with that. Okay. Dimitri asked, do you handle asylum cases? No, I don't handle asylum cases. Okay, so let's see what else we have here. So Volak says, I mean the I-765, I made a mistake on the category and I corrected it. I'd like to know if they're going to consider the initial filing date. Well, first of all, pray that they actually get your correction as an amendment. USCIS is often known to mislabel petitions. So if you didn't have a clear written whatever that this is an amendment or a correction, it's likely that they will open a new case file for you or reject it if there's no filing basis. So you might have to refile it again, not an amendment. So it just really depends, on what you did. But time will tell. Have you gotten your receipt? It depends on it. Also, if you've gotten your receipt, and then you can, try and see how you can intercept. Okay, I'm going to be wrapping up soon. Let me see what else. Somebody on Instagram says, how are you? I'm in the Caribbean and I'm seeking to get you a U.S. work permit. So you don't just get a U.S. work permit. Something has to qualify you for a work permit. You don't get a work permit from outside the United States. Usually you get an immigrant visa or a non-immigrant visa. When you come into the United States and you're eligible for something, you can then get a work permit based on that. Dimitri says, informative life. Thank you so much, Dimitri. Someone says, how soon can I file for my daughter? Did you have an initial question? Because that question is way too broad for me to answer. I don't know. I don't know what your status is. I don't know how old your child is. I don't know, what the basis of. So unfortunately, Odd, I can't answer your question without more. So definitely, call me to evaluate your case and if your daughter qualifies for you to petition. Okay, guys. Well, if you don't have any other questions, I will be jumping off of live. I enjoyed my time with you guys, and I will see you guys next week.